Good afternoon, everyone. I am Divyansh and Rathi, managing partner at Lexidem and Rathi and founder latestlaws.com. I would like to welcome our viewers and distinct panelists to today's Indian Dispute Resolution Center's Lexidem webinar on judicial intervention in arbitration, Boon or Bane. The distinguished panelists for today's webinar are Mr. Jonathan Bellamy, Barrister and Arbitrator, 39 Essex Chambers, London. Jonathan sir has an established arbitration and alternative dispute resolution practice in commercial and construction law as counsel and arbitrator. His practice includes arbitrations under major institutions including ICC, LCIA, SIAC, DIAC, and in various fields like property, natural resources, infrastructure projects, commercial construction. He is experienced in determining disputes involving complex factual and technical issues and evidence. It is our pleasure to have you with us today, sir.
Thank you very much.
Next we have with us Mr. Anil Changaroth, Managing Director, Changaroth Chambers, Singapore. Anil sir is a fellow of CIR London, Singapore, and the Asian Institute of ADR. He is a trained international treaty arbitration and has been in practice with local and international firms and in-house since 1995, having qualified as Barrister of England and Wales. Welcome, sir.
Welcome. Thank you very much.
Next, we have with us Mr. Sanjay Gupta, Senior Partner and Head-Litigation SNG and Partners. Sanjay sir is a practicing lawyer in Supreme Court of India and High Court of Delhi since 1988. He has participated in domestic arbitrations as well as international arbitrations in Singapore. He has worked in various fields of law and has keen interest in ADR, banking and finance, real estate, and personal laws. I would like to express deep gratitude to the panelists for joining the webinar. The moderator for today's webinar is Mr. Shivam Jasra, Managing Partner at Jasra and Jasra Law Offices. Shivam has done his LLM in International Dispute Resolution from King's College London. There will be a question and answer session at the end of the webinar. The attendees are requested to send the questions in the comment section on the Facebook and YouTube. Now I would like to hand over the proceedings to Mr. Shivam Jasra to take forward the proceedings. Shivam.
So I am audible, right?
Yes.
So good evening, everyone. Firstly, I would like to thank Divyansh Rathi for such a generous introduction and further to give me an opportunity to be a moderator in today's webinar. Further, moving on today's panel discussion on judicial intervention, a boon or a bane, I would like to invite Mr. Jonathan Bellamy, sir, who is a barrister and arbitrator at 39 Essex Chambers, to enlighten us and give your views on today's topic. Please, sir.
Yes, well, good afternoon, everybody, and thank you very much indeed for the opportunity to speak. I'm going to obviously speak about the courts of England and Wales and break my words down into two sections. First, more briefly, the question of domestic arbitrations, that's arbitrations seated in England and Wales. And second, of more general interest to the worldwide arbitration community, the approach to the English courts to international commercial and construction arbitration. Now, briefly, on the first aspect of that, domestic arbitrations, the powers of the court are conferred by the English Arbitration Act 1996. English arbitration law has always adopted a light touch approach to regulation of arbitration seated in its jurisdictions. It's been one of the historical features of English-based arbitration, both before the 1996 Act and after that. The courts have recognized that there is a partnership between themselves in court and also between the arbitrators. And a lot of this goes back to the level of trust which existed between the court structure and the City of London going back for centuries. So in relation to arbitrations seated in London, which may of course have Indian-related parties, Indian parties participating, in relation to those arbitrations, unless expressly excluded in the terms of the arbitration reference or the institutional rules, the English court has powers during the arbitration and, of course, after the arbitration in terms of enforcement. I'm going to talk more about enforcement in relation to international commercial arbitrations, because in relation to those, it's that aspect which are principally the interest for parties not based in London. In relation to, therefore, domestic arbitrations, the court has powers ranging from section 42 through to 45 of the 1996 Act to assist the arbitrator or arbitrators in their disposal of the case. And it's that word, it's the supportive role of the courts, which it's important to understand. The courts are not there to take over the function of the arbitration panel. In almost all cases, the first port of call for parties is the arbitration panel. And that includes, for example, questions of jurisdiction, questions of disclosure, documentary production, witness production, and the like. It's only really when the arbitration process fails in procedural terms that there is jurisdiction in the English court to assist the arbitrators in that matter. Now, after the arbitration award in relation to domestic arbitrations, there are really three powers that the English courts have. Firstly, to entertain a challenge based on the jurisdiction of the arbitrator, section 67. Second, to entertain a challenge to the process, the procedural regularity of the proceedings under section 68. And third, in some arbitrations, but not all, the opportunity to consider a true appeal on a point of law only under section 69. The last one's more controversial because, of course, the English Arbitration Act is not based on the model law as it used in many countries in the world. And on that aspect of the case is wider than many jurisdictions. So in relation to English-seated arbitrations, there is a default position of an appeal on the point of law. It is not an easy route. It is only in the most unusual cases. The statistics show that it's unlikely to succeed, but the jurisdiction exists. Now, I'll now turn on to consider international arbitrations, by which I mean there arbitrations with a seat outside England and Wales, for example, in Singapore, Hong Kong, or of course in India. And there, the jurisdiction of the English court is very different and really relates to four different points. The first is the potential jurisdiction in personam to issue in appropriate cases an injunction against a party for proceeding or endeavouring to proceed with litigation in England, known as a stay of proceedings. Second, the potential in rare cases to issue an injunction to prevent an arbitration taking place in another jurisdiction where there's an English-seated arbitration clause, a dispute, therefore, over the appropriate seat. Third, either during the arbitration or potentially after it during the enforcement process, a very limited jurisdiction to issue freezing injunctions to restrain the disposal of assets, to prevent parties from improperly moving or transferring assets away from themselves to frustrate a final award. And finally, of course, the question of enforcement of a final award in England where there are assets of the respondent or losing party in that jurisdiction. So I've set out the four grounds. I don't need to spend long on the first points. The jurisdiction to grant injunctions is established. It obviously is respectful of the jurisdiction of other legal courts, but also of arbitration panels. So it's exercised sparingly. And it's important to understand that it's not directed at the institution, it's not directed at the arbitrators, it's directed at the parties in an appropriate case for breaching an arbitration agreement. There's also a developing area of law in this country about damages claims for breach of an arbitration agreement. And that's something that could come into context with a claim in this country. The second, as I mentioned, is really connected to the first. That's the question of anti-suit. And therefore, you may have a situation in which, for really quite limited reasons, a court is prepared to issue an injunction to restrain parties taking litigation elsewhere in the world if there's an international arbitration in place. The third ground is the freezing injunction that I mentioned. Now, again, freezing injunctions are, of course, exceptional remedies. They're often done ex parte, without notice to the responding party, because to give notice to that party would, in and of itself, frustrate the purpose of the application, because if there is a real risk of disposal of assets, then plainly, if notice is given of the proceedings, then the party will dispose of those assets. But where the arbitration is not seated in this country, there's going to have to be strong grounds and strong evidence as to why, firstly, there should be an order at all, and secondly, that it's necessary for the English courts to grant an injunction. And the best possible example of that is where the assets in question are located in England and Wales. But that jurisdiction exists. It's a matter of discretion of the courts, and would be particularly relevant where there's jurisdiction in a reputable international arbitration jurisdiction. Finally, on this point, I'd like to come to the question of enforcement. Now, this is obviously a point which will be of general interest to those in the international arbitration community. And I'm fully aware that this is a point which has occupied the time of the courts in India at the highest level over the last 10 to 15 years in varying different ways. Now, I'm going to speak obviously about cases involving signatory countries to the New York Convention, where the legal seat of the arbitration is in a New York Convention country. Section 66 of our Arbitration Act gives a general power of enforcement to the English court, but expressly states that it's subject to and will not affect treaty obligations of the United Kingdom and therefore of England and Wales to enforce awards subject to the terms of the New York Convention. Now, the first and most important takeaway point is that the English courts are very reluctant indeed to decline to enforce an award by reference to arguments on the merits. There is, of course, the test of public policy in English law, but it's a very rare case indeed on which any such prospect would take place. So one can assume that provided there is no persuasive evidence of procedural irregularity or bias or fraudulent conclusion, that an international arbitration award would be enforced in England. The exceptions potentially relates to procedure, the procedural irregularity, due process, actual or apparent bias on the part of the parties, or an absence of right to be heard. So it's that regulatory jurisdiction which is important to the English courts. And the cases that have succeeded on this ground have tended to be limited to those bases. So that's what I wanted to say on the English courts. I now look forward very much to hearing the position in relation to India and Singapore.
Thank you so much, Jonathan, sir, for your enriching and insightful words. And I'm certain that it will surely help the viewers and on this subject. So now I would like to request Anil Changaroth, sir, to kindly share his experience on today's topic. Please, sir.
Okay. Thank you, gentlemen, for the introduction. Thank you, Jonathan, for setting the framework. So this is what I'm going to be doing, similar to Jonathan to quite a bit of the extent, because when you're talking about judicial intervention, the similar provisions, similar framework all falls into place internationally, and I'm going to deal mainly with international stuff as opposed to a domestic stuff. So the question is there a trend of minimal judicial intervention in arbitration rulings and so on? You've got to think about which country you're from and what each of these countries, how they react to arbitration matters. In my discussion, I'm going to be talking broadly about what you mean by judicial intervention in arbitration, first of all, and then take a look a little bit about the pros and cons of judicial intervention. Now, insofar as some of the cases that I might cite here, I am not going to go into a detailed analysis of what the case said and then how it came to a conclusion and how it was drawn, because we're trying to just establish the fact whether or not should courts interfere or should they not interfere. And if you're wondering about whether they should or they should not, you're just looking at the essence of what these cases may have set out in their decision. So that's what I'm going to do. Now, very interesting. I mean, most of you may know of our Honorable Chief Justice, Mr. Sundaresh Menon. He's well known internationally. In 2013, in October, in a speech called Judicial Attitudes Towards Arbitration and Mediation in Singapore, this was 2013, right? And this is what he said, a couple of very interesting things he said. He said that at the heart of arbitration law is the need for a delicate balance between upholding the consensual nature of arbitral process and maintaining a degree of judicial oversight to ensure that fundamental standards of procedural fairness are abided by and the public policy is not contravened. Both aspects, I think Jonathan had spoken about as well, right? So that's the essence of it, while that it has to be a delicate balance between the consensual nature of arbitration and the need for some framework and control in terms of whether procedurally they've done it right and whether or not public policy issues are considered, right? Now, you'd also, those of you who are familiar with model law, unlike in UK, in Singapore, we have the International Arbitration Act that takes a large portion of the UNCITRAL's model law on international commercial arbitration called the model law, right? Article 5 of that model law provides that in matters governed by this law, no court shall intervene except where so provided in this law. So the model law sets out the framework when the court can interfere, right? Now, it's not really intended, if you think about that, it's not really intended to signify a hostility towards a court intervention in the appropriate cases, but rather a primary objective to enhance the certainty as to the permitted extent to which judicial intervention takes place. So it's again comes back to this balance. Why would the model law say that I allow the courts to intervene, but only in specific circumstances? Because again, they want to have a fine balance between how the arbitration is party autonomy and party driven, and party has the right to the freedom and so on and so forth. So keep that in the back of the mind. Now, again, in international arbitration, many of you may be familiar with Professor John Paulson. In an article in 2013, where the article was "Why Good Arbitration Cannot Compensate for Bad Courts." This is what he said in that. He said that arbitration unchecked inevitably means arbitration abused. And he also said that an arbitration-friendly venue is not the one where awards are totally inviolate, but rather indicates a degree of indifference that invites abuse. So again, it comes back to how do you balance that, all right? Now, then I go on to the next part, which is what is judicial intervention in arbitration, right? Now, insofar as Singapore is concerned, it's a pro-arbitration, it takes a pro-arbitration stance and policy of giving, allow the tribunal to deal with the aspects and only interfere when it's totally and absolutely necessary, right? and the courts generally refuse to interfere and will only intervene in arbitral proceedings under exceptional circumstances, right? With the court is resisting the temptation to engage in legal merits of the award. So there's a case law on that. It's a 2015 case of AKN and ALC in the Singapore Court of Appeal that said this about the Singapore's position on whether or not they interfere in arbitration matters. Now, why would a court then interfere in arbitration matters? The first aspect would be in considering the arbitral proceedings, right? The court may leave it, yes, it may leave it to the arbitral tribunal to determine how the procedure and what not should be followed, but it will take steps if it is matters such as that are brought to the court and there are issues about validity of the arbitration agreement, whether it exists, whether the validity is disputed by party, and it all depends on the evidence that's presented to the court. And there is also a 2015 case law that talks about this aspect about whether or not the arbitration agreement is valid or not. So it sets in place why courts may be referred to in dealing with these things. Now, remember I mentioned to you that they have the Singapore International Arbitration Act. Now, the Singapore International Arbitration Act, Section 6 and 7, sets out and it deals with parties instituting court proceedings, court making orders on terms and conditions as it thinks fit, stay of proceedings, and also making interim and supplementary orders, interim measures, which Jonathan had mentioned. Singapore has that as well under the Singapore International Arbitration Act, Section 6 and Section 7, right? Now, the courts can also then consider dealing with arbitration matters when there are talks about challenges in the award, right? Again, an aspect that Jonathan had spoken about. Interestingly, in the Singapore International Arbitration Act, Schedule 1, it incorporates all of the model law except Chapter 8 of the model law. And it provides the court with powers to intervene and challenge arbitral awards if necessary, but on specific terms. And what we do in the IA, the International Arbitration Act, Singapore International Arbitration Act, is because we adopt the model law, the reference is in Article 34 of the model law. And it says in what circumstances would the court interfere? And the main points, again, similar points that Jonathan had highlighted, is when the party to the Arbitration Act is under some incapacity, A. B, that the arbitration agreement was invalid. C, subject matter of the arbitration was not capable of settlement by the arbitration. D, that the tribunal was improperly constituted or the arbitral procedure was not in accordance with the party's agreement. E, the party making the application was not given a proper notice of the appointment of arbitrator or the arbitrator proceedings, or was otherwise unable to present his case. F, the award dealt with a dispute not falling within the terms of the arbitration agreement. Or G, the award was contrary to public policy. Now, this issue of public policy is something I don't think we should go into this discussion because it's a massive area. It's got a whole lot of case law on it. It's got how the courts had taken position many years ago and how it's changed over time and how the courts look at public policy these days. So that's a detailed exercise by its own. All right. Now, in the IAA, along with Article 34 of the model law, Singapore's IAA also has got two other parts, right? Section 24 of the IAA says that when making an award, it was induced or affected by fraud or corruption, the court can interfere. So in Singapore, we specifically set that up. And Section 48 of the IAA also says when a breach of natural justice occurred in connection with the making of the award by which the right of the party were prejudiced. Right. So in these two additional circumstances, other than Article 34 of the model law, the courts can intervene. All right. Now, again, what else would the reason be for courts to intervene? Refusal of enforcement of awards. Article 36 of the model law sets out the grounds. Those are similar to Article 34 of the model law. for the grounds of why you can the courts can interfere in the matter. So that's the provisions are very clear, and the circumstances under which the courts can interfere is very clear. Next, I go on to some of the pros of judicial intervention in arbitration. So now that we set the framework and we tell you what the law is in relation to why or how the courts can interfere, some of the things that the reasons why the courts want to interfere or need to interfere is that you must appreciate that the court's role is really to crystallize the law on various aspects, right? And arbitration as well, right? Now, remember I mentioned to you that our Honorable Chief Justice in the 2013 lecture, he also said this, right? He said that courts are there to define and to develop the law by declaring what the common law is, laying down the boundaries on permissible and impermissible conduct, and providing remedies, enforcing of the law, right? And he quoted from a Professor Owen Fiss in an article called "The Form of Justice," enforcing and thus safeguarding the integrity of the existing public norms or the supplying of new norms. And that's what the courts are there to do. So if you take this fundamental role of the courts, you can appreciate why in certain circumstances it is necessary for the courts to take steps insofar as arbitration matters are concerned. So this tells you that really the courts may need to come in when there's some certain aspects of the arbitration that's really out of line to what is norm, what is known to the world in the practice of law, and what is known as to what the courts do, right? So, for example, there are aspects of international norms that whether or not you followed and complied with that. Again, Jonathan had spoken about the New York Convention. So the question then is, have the parties in the arbitration consider these aspects, and whether or not when in enforcing they've taken these points in the New York Convention into consideration, whether or not there needs to be clarification and expansion on the applicable principles from these instruments, like the New York Convention or the model law. In that case, you know that the court has to come in, right? Now, again, the court is also there to be kind of like a quality control in the awards that are passed down, right? And it provides a supervisory mechanism over arbitration. Again, a point that Jonathan had succinctly put across, that it's a supervisory role that they perform. So you have to appreciate that if the courts are purely doing that and not interfering in the substance of the arbitration and the evidence that were presented, then you know that the courts are assisting the arbitration regime or the arbitration practice as a whole. All right. Now, in Singapore, there are a couple of court cases. I'm not going to go into the details, although I have a paper that I've put together for this presentation. I will be sending it out to the center, and they can then take a look at it. There's a 2019 case that talks about whether or not there was procedural violation, whether there was an issue about the wrong choice of seat, wrong number of arbitrators. So a particular case in 2019 had considered that. So you can see why the court needs to come in, because it was not dealt with appropriately in the arbitration. In another 2018 case, the issue was about court action was commenced, and then whether or not, if you commence court action, does that prima facie repudiate the arbitration agreement, and whether or not the arbitration agreement that gets thrown out, or should the court then say, hang on a minute, parties have decided that they want to have their matter arbitrated, so they must have the power, and you must allow arbitration to go forward instead of us dealing with it by way of court proceedings. So that was a 2018 case. So there are several other cases that I've cited. The 2013 case that reiterates the principle that parties have no right of appeal in the court when it talks about merits of the arbitration award. 2011 case where the High Court set aside international arbitration award on public policy grounds. That was a very early stages of public policy, but Singapore has grown and moved far forward, and then they now have a very restricted grounds for public policy defenses that can apply. So these are some of the pros of why you'd want to go into court intervention. Now, why shouldn't the court interfere? the main point would be that you're detracting from the issue of party autonomy. That's a clear point why courts should not interfere. Some of the other reasons why the court should not interfere is that, you must appreciate that arbitration is one of the forms of appropriate dispute resolution. I don't call it alternate dispute resolution because we are way beyond the time when all other dispute resolution mechanisms were alternate to arbitration or litigation. These days, it is what is more appropriate. You have things from negotiations to mediations to neutral evaluations to expert determination to dispute boards, adjudication, arbitration, and litigation. So the point is that the courts are there to deal with one form of dispute resolution. Arbitration by the party's choice is there to resolve the dispute in another method. So why should you have both methods, one after the other, and just prolonging the matter and dragging out the dispute between parties? So that's one of the reasons why you'd say, really, we don't want interference insofar as adjudication is concerned. Now, taking that point, you might also consider some of the other dispute resolution mechanisms, like dispute boards have decisions, and then adjudications have determinations, and mediations have got agreements. Then the Singapore Convention on mediation is a perfect example. All of these are binding on the parties. So if it's binding and parties have come to that decision, whether by consensual dispute resolution mechanism or adjudicative dispute resolution mechanism, why should the courts then interfere, right? So that's part of, or one of the reasons why you shouldn't interfere as well. But in summing up, in the totality of things, if you look at the first part of the points of why I said why the courts need to interfere, what are the framework for it and the basis for it, you can well appreciate there is a need for a check and balance. And if you talk about Boon or Bane, I seriously think if the judicial system in the country is well defined and clearly set out, it is only there to assist. It is only there to be supportive, and it is only there to make it very clear and set out the clear framework so the parties don't end up going all over the place in taking matters to arbitration. And that's it. That's what I want to say in broad sense. And then I think we can take a lot more questions and answers when we come to that. Thank you very much.
Thank you, Anil sir, for putting forward your views on today's topic. And we would surely eagerly wait for the paper that you have put together on today's topic. Now, moving to Sanjay sir to share his views on today's topic, I would like to invite him for the discussion. Please, sir.
Yes. Well, I think I was mute and was not able to speak. So, first of all, many thanks to dear Divyansh and Shivam for their kind words. It was also a pleasure hearing the views of Mr. Jonathan and Mr. Anil. But all they have said, there is now little left for me to say, in as much as there is not much of a difference into the position what exists here in India. The reluctancy of the courts to get into the merit of the case, the emphasis on the public policy, procedural irregularity, actual bias, and then quality control, delicate balance to be maintained, all those parameters hold good in context when we come to the arbitration in India. Of course, in India, it has taken time to evolve. It has evolved during the period of time when we talk from the Act of 1940, and then ultimately the Act of 1996 was enacted. So before I come and say what all is there in the position which exists in Indian law, I would like to first congratulate Divyansh for having set up this Indian Dispute Resolution Center. the existence of a institutionalized arbitration center is the need of the country, in as much as the existence of any such institution in many ways ensures that there is no involvement of judiciary as far as the appointment of arbitrator is concerned. So that gives a kind of a comfort that for the appointment of arbitrator, the person having opted for an institutionalized arbitration, there may not be a need to go to the court for the purpose of appointment of arbitrator, and it saves a lot of time and also the money. As far as the position on the law is concerned, the law in India is also, when it comes to the judicial intervention, is well settled. It is a laid down law that if there are two plausible views and the arbitrator has taken one of the plausible view, the court will not interfere. The court is to interfere only when, on examination of the material placed before the court is to rule that the arbitral award is perverse and or has been rendered without basis. The court will also not interfere unless it is ruled that the award is against justice and morality, or it would shock the conscience of the court. The Supreme Court in India has repeatedly made out these standards while dealing with the challenges made to an arbitral award. The Supreme Court, while declaring the law in this manner, is ensuring a minimal intervention in arbitration. If we look even into the legislative intent, the legislature, while enacting Arbitration and Conciliation Act 1996, is specifically provided in the statement of objects about the main objects, amongst others, is to minimize the supervisory roles of the courts in the arbitration process. This was so specifically provided in the objects at the time of enactment of the Arbitration and Conciliation Act. This act was amended in 2016, and even in the statement of objects and reasons, in the amending act of 2016, one of the reasons given for amendment was that the interpretation of the provisions of the act by some courts in some cases has resulted in delay of disposal of arbitration proceedings and the increased interference of courts in arbitral matters, which tend to defeat the objects of the case. I will try to touch upon with respect of some of the cases. Of course, I am conscious of there being some time constraints as well, so I would like to deal with some of them at the appropriate states. Now, why there was a need to make these kinds of amendments? These amendments were necessitated on account of there being some conflicting judgments which were rendered by the court from time to time. There was a necessity of confidence to be generated globally that India is a conducive territory when it comes to arbitration, and this confidence can be generated only when it can be demonstrated that the judicial interference in the arbitration process, irrespective of the award is domestic award or a foreign award, is least, and that the court will not interfere in a regular manner. Now, I have already pointed out that the court will not, the intervention by the courts is to be limited to provide necessary aid and assistance to the arbitral process. The success of arbitration proceeding is ultimately dependent on underlying support of the courts for assistance at various stages of the proceedings, and particularly for the enforcement of the arbitral award, whether domestic or foreign. But the support is to be minimal, and therefore what Anil said is that there has to be a delicate balance which is to be maintained. The balance is where the court is to enforce and where the court is not to enforce. Earlier, if I go back to the history of the Arbitration Act in India, the Arbitration Act initially of 1940 which had ample scope for the intervention and to reduce the excessive intervention which was happening in the Act of 1940, the Act of 1996 was enacted. The emphasis is made now. I would like to emphasize on Section 5 of the Arbitration Act of 1996, which provided that, and I would like to read Section 5 for the benefit of everybody. Notwithstanding anything contained in any other law for the time being in force in the matters governing by this part, no judicial authority shall intervene except where so provided in this part. Therefore, the judicial intervention is to happen only wherever is provided in the Act or where the provisions contained in the Act and not otherwise. The 1996 permits judicial intervention in domestic arbitration only in circumstances mentioned in the Act, and some of the instances where the court can interfere would be the instances like when it is brought to the notice of the court that the parties have agreed to settle their disputes under arbitration, the court would resort and try to refer the matter to the arbitrator. The party can approach the court under Section 11 for the appointment of an arbitrator when there is a clause in the agreement for settlement of dispute by arbitration. The court can pass order under interim orders under Section 9 of the Arbitration Act so as to give such relief. But ultimately, any of such order which is now passed by the court has to be continued in the arbitration proceedings because it has been provided that an arbitral tribunal has to be constituted within 90 days of the passing of any such order. The court can also interfere under Section 12 and 13 of the Act if there is a challenge to the appointment of an arbitrator giving rise justifiable doubts to the independence or impartiality of the arbitrator. Then, as and when the award is passed, a challenge can be made under Section 34, and under Section 34, parameters have been set up by under the Act itself that as to how the court would intervene. What are the principles which would be applied by the court to examine the validity and legality of the award? And it has been now the court has held that the court will not get into the merits of the case. The court would determine itself and examine itself the extent of public policy which the court would see whether there is a violation of the public policy or there is no violation of public policy. The law has evolved over a period of time in India, which has necessitated various amendments to be made. And just to give reference and brief background as to the amendments and the reasons for making those amendments, I would very, very briefly touch upon the case law and the pronouncement of the Honorable Supreme Court of India. I would go back to the year 2002 when, in the matter of Bhatia International, the Supreme Court held that even the Part 1, which relates to domestic arbitration, can be made applicable unless it is excluded by the parties by their agreement. Now, this judgment given in Bhatia International was not well received globally, but the fact is that the judgment continued unless till 2012, when the Bhatia International was overruled by the Honorable Supreme Court in the case of Bharat Aluminium, when it was held that reference to a seat or a specified law governing arbitration is sufficiently to implied, excluding the Part 1 of the Arbitration and Conciliation Act. Thus, what was held in Balco was that Part 1 will not be automatically applicable unless the parties agree to be governed by the provisions contained in Part 1 of the Arbitration Act. Now this journey from 2002 till 2012 And to avoid this anomaly, when the Parliament was amending the Arbitration Act in 2016, there was a proviso added in Section 2 of the Arbitration Act so as to clarify that subject to an agreement to the contrary, some of the provisions of the Arbitration Act shall also apply to international arbitration, commercial arbitration, if the place of arbitration is outside India, an award made in such place is enforceable and recognized under the provisions of the Part 2 of the Act. Now the another view, as I said in the beginning, the law in India has evolved over a period of time. So the public policy has always been an important ingredient for the court to rule on the validity of an award. There are various views which has been taken on the applicability of the public policy. I would not dwell much upon various case laws, but would very briefly say that in 1993, in one of the case of Renu Sagar, while dealing with the expression public policy, it was held by the court that in respect of enforcement of foreign awards, the doctrine or public policy would mean the public policy as applied by the courts in India. It was held that it would mean public policy of India and not the country whose law governs the contract. Thereafter, again, in one of the another matter of ONGC in the year 2003, it was held by the Supreme Court that there is no necessity of giving a narrower meaning to the term public policy of India, but a wider meaning is required to be given so that patently illegal award passed by the arbitral tribunal could be set aside. Now, in this background, in the year 2013, I'm just going by the year wise, the court in the year 2013 in the matter of Shri Lal Mahal held that the expression public policy of India for the purpose of enforcement of foreign award must be given a narrower meaning than when enforcement awards under the domestic arbitration. It was held that contravention of law alone will not attract bar of public policy, and something more than contravention is required for enforcement of foreign awards to be contrary to the public policy of India. So on account of, again, what the point I am making here, that in India, the legislators have been conscious of the views which were coming from the Supreme Court. They felt that there is a necessity of carrying out some amendments so as to define even the meaning of public policy, and consequently an amendment was made in the year 2016, and there were substantial amendments made to Section 34 as well, so as to define what would be the public policy and how and under what circumstances the court would look into the decision when there comes a question to decide the validity of an award rendered by an arbitral tribunal. The court is not to reappreciate the evidence. The court is not to go into the merits of the case and is not to impose its own views over the views of the arbitrator, is the consistent stand which the court is to take in context of arbitration. Now, the other aspect which I would briefly touch upon would be the aspect when it comes to the appointment of arbitrator. Under Section 11, the court in India has power to appoint an arbitrator when the parties to an arbitration agreement are not able to appoint an arbitrator, or one of the party refuses to appoint an arbitrator, and then the court is vested with the power to interfere and appoint an arbitrator. There has been a controversy with respect to the appointment of the arbitrator, whether the court is exercising administrative power, the court is exercising judicial power, whether the decision given by the court can be a subject matter of further challenge. All these anomalies were also removed by the Parliament while amending the Act in the year 2019, and a clarification was provided. Thus, like to conclude, I will surely say that a judicial intervention in the arbitration process is to be minimal and is to be within the four corners of the law. Any excessive interference by the court will surely be a bane, and the enactment itself, the object of the enactment, and all further amendments which have been carried out are in the direction of having minimal interference by the courts in India. Thank you very much.
Thank you, Sanjay sir, for your insightful and enriching words. Now I would request Divyansh Rathi to take the charge from me and go forward for the Q&A question and answers round. Divyansh.
Thank you, Shivam. My first question is for Jonathan, sir. So the question is, what will be the effect of recession which the world is going to witness after the which is brought by coronavirus on the ADR world and especially on arbitration field? So how is arbitration field going to get affected with due to coronavirus?
Well, there's a big question. It's an interesting question, isn't it? Well, I think firstly that the shares in airlines are not going to get better for some time. Conference centres and many physical providers of services around arbitration are going to suffer. Now, your institution is an interesting example of a recent model which may well be able to adapt quickly because it hasn't established a historic model. My own view is that, I mean, it's right to say that before the coronavirus, many procedural hearings were held remotely, whether by telephone or by video conference. But I think that will continue. I think the days of people flying long distances for short hearings may be limited. That said, parties, I think it's in the human nature, will want physical hearings where there are witnesses to be examined and cross-examined. It's also, I think, right that physical presence can promote settlement discussions in a way that non-physical presence can. So to answer your question finally, I think there will be long-lasting changes, particularly at a pre-final hearing level. I think a lot of institutions will be able to streamline their processes to deliver awards within fixed time limits in capped amounts of money. But I do think that there will be a return to physical final hearings, at least for evidence.
Thank you, sir. I would like to also ask Anil sir to share his views on arbitration and coronavirus and how Singapore adapting to it in Singapore Arbitration Center and what's his experience during these times. I think so.
You have to. Okay. Yes. Thank you. My views are slightly different from Jonathan's, mainly because I think we take technology a lot more. We're a lot more comfortable with technology. I'm not saying many of the other countries aren't. So starting point is this: on COVID-19, a lot of people have said there's going to be a massive number of disputes, right, arising at the end of this. My take is that it's not going to be a massive number of disputes. It's going to be a massive number of issues, right? Because if you say disputes, you're talking about it going to arbitration and going to trial. When you say issues, it's because all the parties that are coming to the table, they have issues about how to proceed. All the parties are in a crunch situation where they're financially strapped, and they don't want to end up in litigation or in arbitration. So the chances are a lot of people are going to be a lot more collaborative in the approach they're going to take to resolve issues that they have. All right, so that's one aspect of the COVID-19. The next aspect of the COVID-19 is, I think you're going to find a hell of a lot more matters being dealt with online, right? Whether it's mediation, whether it's neutral evaluation, everybody's going to turn to an online method of resolving disputes. And interestingly, my take is this: insofar as arbitration is concerned, I think there might be a surge in arbitration matters because there's that avenue of not having to travel, right, and just having it done by remote, right? So while people may think that, because of this current atmosphere, you might find people not resorting to arbitration because they want to have a physical appearance, my take is that I think there's going to be a great encouragement to have it done online. Now, the third point on that is this. Let's talk about online for a quick minute. I do a lot of mediation and other stuff, and I've done it online. The interesting thing is you get to see the parties' faces, all of them, on one screen, right? So can you imagine in an arbitration, right? My take is this. In an arbitration, I get to see all the parties. I get to see an expert who's speaking, right? And while that expert is giving evidence on one side's story, I can see the expression of the counsels on the other side, the witnesses on the other side, the experts on the other side, and the expressions. And they might give me hints, right? Now, of course, they talk about online and the problems with security and whether or not witnesses are being coached in the background. But at the end of the day, Jonathan would agree with me, I think, to some extent. A case is as good as the material and the documents that are available. The witness can sugarcoat anything. He can be prompted by someone who's sitting behind in another room and prompting him to say A, B, C, D. But if the A, B, C, D doesn't play out in the documents that you have, the arbitrator is best placed to decide, on a virtual screen, I've heard this gentleman speak. I don't really think he may have been coached in the background, but it doesn't matter. When I compare that against the documentation, this is what happened. So in the totality of things, if you take all of these elements that I said, we are going forward to an environment where there's not going to be disputes fought out, but disputes and issues resolved amicably in a consensual manner with a more collaborative approach. And if hearings are going to go on, I think people are going to be very comfortable now with an online basis, and they have to balance it. Of course, you still have the issues of privacy and security on arbitration and online and all that. That's all different topics. It's for another day as well. All right.
Thank you, sir. Thank you, sir. My next question is for Sanjay, sir. Sir, even though Section 5 of the Arbitration and Conciliation Act 1996 lays down that there should be no intervention of judicial authority, but litigants prefer Section 9 over Section 17 in India for providing interim reliefs in arbitration proceedings. So what is your take on it?
Section 9 is something which is provided in the statute itself. So if a party is to go and approach the court under Section 99, there is no bar. So they are within their rights to go and approach the court under Section 9. And the court would then examine whether there is a case for the grant of interim injunction or not. So it is a right available under the statute. But now after the amendment, the safeguard is earlier what was the position? The party would go to the court, take an interim stay, and will not take steps for the initiation of arbitration. Now, it has been made mandatory that after you have approached the court and after you have got an order under Section 9, the process of arbitration must start within 90 days. And all those powers which are vested in the court are then exercised by the arbitral tribunal constituted post under Section 17 of the Arbitration Act. So the power which is exercised under Section 9 is pursuant to the provision contained in the Act itself.
Thank you, sir. So, my next question is for Anil, sir. Sir, there is a Niti Aayog report which says that India is taking 2,500 days in disposing the Section 34 objections, which provides for setting aside of arbitral award, application for setting aside of arbitral award. The petition is filed in the court. So how can India take steps to reduce this duration of 2,500 days, which is equal to about 7 years, to reduce such time?
Is the timeline
Yes,
set
sir.
somewhere? Where is that set?
There is no timeline for the court to dispose of, so the courts take it their own time.
Okay. Then may I start that by saying that Sanjay mentioned a couple of very interesting things about what your amendments are doing, right? And when he spoke about, I think this 1940 and Section 5, about no judicial intervention unless exceptional circumstances, is similar to the model law. So that's the framework. And I like the points about what he said about the amendments. And what the amendments are doing is streamlining arbitration and when and how arbitration matters will be dealt with, right? Now, so if you have that system in place, right, surely you can get the procedural steps also done expeditiously, right? Now, how do you do that? Again, something Sanjay had mentioned is about ad hoc and institutional arbitration. If you have an institutional arbitration, it sets out a framework. Now, insofar as the court is concerned, it's like any other court hearing. I mean, if a matter comes up to court, it depends on the court and then what their timelines are. So I don't think you can impose stricter timelines to the courts to resolve just arbitration matters as opposed to other matters. Now, if it was still dealt with by the institutions, of course, you got a time limit and it moves along fast. I think the courts need to appreciate that with the amendments that have been brought on in India, you are moving to a regime where very little interference with arbitration matters. So if there's very little interference with the arbitration matters, if a matter does come, we must expeditiously move it along, clear it, get it off the table and move along. So I think it's a I don't know whether to say it's a cultural thing or a fundamental appreciation that what arbitration is doing for dispute resolution. What the amendments you have made is improving that form of dispute resolution, and therefore let's rely on that. And therefore, when the court has to interfere, let's do it expeditiously. So it's a very difficult to explain it any other way than that. I find.
So, Sanjay sir, Sanjay sir, thank you, sir. Sanjay sir, what would be your comments on how to improve this timeline for the Section 34 petition to be disposed by the courts? Because in India we have different levels. First, the district court deals with it, then the high court, and sometimes the cases go to Supreme Court. So eventually drags it through 3 institutions. So, Sanjay sir, how can we reduce the timeline for such petitions?
It all depends about the perception of a judge who is dealing with Section 34. If we have seen now instances, if I have to say for Delhi High Court where I practice, in many of the cases I have seen that the court on the first date of hearing is dismissing the petition, holding that no interference is required, and therefore the petition is declined on the first date of hearing itself with no further hearing happening. The other case instance would be that where the court finds that there is some merit and there is a need to hear the other party, and when the notices are issued and the other party is heard. That too, of course, sometimes it takes longer. But in my understanding, under now in 2016, when the Act was amended, there was a time limit fixed that the objection has to be decided and within a period of 1 year. In the amendment when it was carried out in 2016, I'm just recalling that was the position when it was done. The fact remains, you really cannot have a control when a party is to go in further appeal and the matter goes appeal to the Supreme Court. And as we all know, the Supreme Court doesn't interfere so easily unless there is a substantial question of law which is involved. Earlier when Anil said the balance to be maintained, sometimes the judge also flaw in when they are delivering the judgment. Like recently, I did not touch upon the point. Recently, as early as April 2020, there is a decision by the Supreme Court where they have gone on the merits of the case in the matter of NAFED, which is not well appreciated amongst the among the circle. So sometimes, yes, in some of the cases, there is an element when the law is not appreciated in the correct perspective. But again, in the Indian context, delay is something which is bound to happen unless, depending upon the number of cases, the number of courts, and the limitation which is there across the country.
Thank you, Sanjay sir, for such beautifully articulating the answer. My last question is for Anil sir. Sir, the India has improved its rank in ease of doing business from 164 to 61 in last 6 years, but we are still lagging at 161 in enforcement of contracts. So how can we improve our position in the enforcement of contracts area and learn from something from Singapore, your jurisdiction?
That's a tricky question, because enforcement of contracts, I suppose you may want to see whether or not the dispute resolution mechanisms. I mean, okay, I find it strange that you have the difficulty about enforcement of contracts, because the judiciary or the judicial system in India, I mean, it's known to take a long time. So parties, whether or not they want to go into a fight, and a drawn-out fight is something that they want to consider, and they want to try and make sure that they get into a contract that's workable and carry on. So again, I think it comes back to a fundamental cultural point. Are you entering into a contract just for really entering into a contract that it's workable? If it's workable, then why shouldn't you stay on it? And if it's not workable, what are the regimes that you have in place? What are the mechanisms that you have in place to resolve those things? So again, it comes back to my point about appropriate dispute resolution. If you have a whole array of mechanisms, I suspect sometimes what you have is that the parties are saying, there's an arbitration clause, don't worry about it. If we get into a fight, let's just drag it out. And even if we drag it out in arbitration and we don't get an answer that we're happy with, let's take it to court, and the court will take the number of days that you just mentioned. But if there is a regime in place where it gives you clearer, better forms of dispute resolution that people sign on to, like for example in the Singapore Institute of Architects have got a standard form contract that has got mediation, expert determination, and arbitration all sitting on it's a minor works contract, all sitting on the same platform. If you use the FIDIC contract and the dispute boards mechanism is a far better way to resolve the disputes, if at all it arises. So if you have a mechanism that can show you that we can deal with it in any which way, you'd find that parties would eventually start paying attention to the contract they enter into, paying attention to not wanting to have it breached, not wanting to fall out for it. Again, taking the part about breach, if you think about the COVID-19 situation, you've got issues about force majeure, you've got issues of frustration. The FIDIC contract has got issues about exceptional events. Do you want to get into all of that? Because if you analyze all of that, you may not, the current situation may not apply to all of those things. So it's a very large question. I call it a large question because it's all encompassing, and we take our law from English law from a long time ago. So I think maybe, I don't know whether Jonathan's got any points to add on that, but if you have a clear system in place, you have a clear jurisprudence in place, chances of you improving on contractual carrying out of the contracts or dispute resolution will all start to improve as well.
Thank you, sir. I would like to ask Jonathan, sir, to share some of his views on this question.
Well, briefly, due to the time I know you've got available, I'm responding to Anil and obviously the very interesting points that Sanjay's made about India. I think we've struggled as well in England with procedure and to an extent delay and cost in arbitration. No one is exempt from this. I think it'd be right to say that if and when in the unusual events it comes to court, we've been pretty good. And that's partly because we have arbitration matters can only be heard by the Commercial High Court. Commercial High Court. There's a specific arbitration procedure. And therefore there's a streamline. So the judges that you will be in front of are almost certainly arbitration specialists themselves in practice. So that's a very important point. Of course, the volume of cases in India is just extraordinary. I remember looking at the Law Commission some 5 or 10 years ago, the interesting paper the Law Commission published of India on the restructuring of the commercial system. I mean, the numbers were just mind-blowing, really. Very, very interesting. Another way we've made it really more difficult is just by increasing court fees. Court fees now are really quite meaningful. And that's another way of doing it. But as I say, no one's exempt from this. Proportionality of dispute resolution procedures is important. Look at all the main institutes, including SIAC, ICC, and elsewhere, Chartered Institute of Arbitrators in England. They've got now cost-controlled mechanisms for cases under $2 million and the like. So I think that's all I wanted to say, just to chip in, and thanks for the opportunity.
Thank you so much, sir, for sharing your views on this question. With this, we have come to the end of our question and answer session. I would like to thank our panelists on behalf of the Indian Dispute Resolution Center, Jonathan sir, Anil sir, and Sanjay sir for sparing time out of their busy schedules for joining today's webinar. I would like to thank Vivekananda Institute of Professional Studies, Northcap University, Ansal University, Jasra and Jasra Law Offices for supporting today's webinar. To know more about Indian Dispute Resolution Center, viewers can visit the website theidrc.com or contact at info@theidrc.com. With this, we would like to wrap up this session. Stay safe and thank you for joining the session. Thank you, sir.
Thank you. Thank you very much.
Thank you so much.